Hello, everyone. Thank you so much for joining us today. I'm going to give everybody a few more minutes to log on and another minute or two, and then we'll get started. All right, we'll go ahead and get started. Welcome, everybody. My name is Katie O'Connor, and I am the Deputy Chief Counsel at Demand Justice, an organization that's building a progressive movement to restore ideological balance and legitimacy to our nation's courts. Thank you all for joining us for this important conversation. I want to start by thanking our wonderful partners, the NAACP, the National Education Association, and the Student Borrower Protection Center. We are very lucky to be in this fight with you all, and I'm looking forward to our discussion today. We are here to talk about President Biden's student debt cancellation plan and its fate before the Supreme Court. As you all probably know, last fall, the Biden administration announced a plan to cancel some student debt in order to help mitigate the economic harms caused by the COVID-19 pandemic and provide much needed relief to millions of Americans who are struggling under the crushing weight of our nation's $1.7 trillion in student loan debt. The plan was immediately challenged by 6 Republican-led states and a pair of student borrowers whose loans didn't qualify for relief, and it's been blocked in the courts ever since. The Supreme Court heard oral arguments in the case 2 weeks ago and will decide the case by the end of June. This issue is one that is nearly universal. In the richest country in the world, fewer than 1/3 of students are able to pay for college outright, and the rest of us graduate with debt that for some is crippling. That's why so many people showed up to the oral arguments to express their outrage at a court that's inserting itself into a fight that is purely political and threatening to strip us of the relatively modest relief the Biden administration seeks to grant. And that's why so many of you all are joining us today. We are so fortunate to have 3 experts here to help us break down what this case means and what happens next. And I won't waste any more time getting to them. So I'm going to introduce our panelists. We are joined today by Jeff Burritt, staff counsel in the Office of the General Counsel at the National Education Association, Wisdom Cole, the National Director of the NAACP Youth and College Division, and Mike Pierce, Executive Director and co-founder of the Student Borrower Protection Center. So let's get started. I'm going to be directing questions to you all individually, but you should feel free to weigh in whenever you'd like. I want it to be conversational. And I do plan on getting to some audience questions at the end of the hour. So if you're in the audience and have a question, please feel free to go ahead and put it in the chat or in the Q&A function, and we'll try to get to it later. So Mike, I'm going to start with you. Can you talk about the massive volume of student debt in this country at this moment, who it impacts, and how the COVID-19 pandemic worsened this crisis?
Absolutely. And I do want to say thank you so much for having me today and for the chance to talk about this, and to my friends and coalition mates here and joining this conversation. Student debt has become a crisis for multiple generations of people now, for exactly the reasons that you noted at the top, Katie. The volume of debt has grown exponentially over the course of the past 20 years. The average balance held by a borrower has grown at the same time. So this isn't a situation where you have just more people going to college and taking out modest debts that they can repay. Instead, the debts themselves have grown. And there's a stat that I think illustrates this really well. People are not succeeding in these debts. Going into the pandemic, roughly 1 in 4 student loan borrowers was past due or in default on a student loan. And for every 2 people that pay off a loan in 12 years, there are 3 more that are even deeper in debt than they were when they first started. So that is not just that there is this debt and that this debt is presenting a burden to folks, but the debt's actually a debt trap. People are making the payments that they owe every month, and they're falling further and further and further behind. All that the COVID pandemic did was give Congress the opportunity to pause the student loan system. So for most people, and not everyone, certainly, there's people with older loans made by banks and guaranteed by the federal government that were left out. There's people with private loans that were left out. But for most people, student loan interest, monthly payments, and debt collection have been paused for 3 years. It'll be 3 years this week. But all that did was put the student loan system in limbo. It didn't do anything to set people free from these burdens that are crowding out economic opportunity, home ownership, family formation, retirement security, all of these different pieces of middle class life that remain just as far out of reach for folks as they were the day the pandemic struck.
Thanks. Wisdom, I'm going to go to you next. In the NAACP's brief before the Supreme Court, you argued that student loan debt poses a barrier to racial justice in this country. Why is this issue a racial justice issue?
Yeah, thank you so much for that question. And thank you, Katie, so much for the invitation to be a part of this conversation on behalf of the NAACP. As you can see, I'm repping, the amount of debt that we all have collectively here from this phenomenal crew neck that I got from the Student Debt Crisis Center. But recognizing that, we have this much crushing debt that is impacting millions of Americans. When we talk about student debt, if we're not talking about the racial justice lens, the racial justice implications, then we're missing the mark, we're missing the moment. The average Black borrower has $53,000 in student debt, more, I think about 24,000 more than their white counterparts or peers. And when we think about education as a whole, right, and the way in which education is delivered to people of color, to the Black community, is that education is supposed to be the passport to our future, right? It's supposed to open up opportunities for economic development, for an economic future, to become homeowners, to become business owners, and to have discretionary, generational wealth building opportunities. But oftentimes, education is becoming a massive barrier for millions of Americans because of the burden of student debt, right? Let's talk about the people who start school and don't even finish school. Many of those being, Black and brown folks who do end up graduating and are looking for a job, continue to face job inequality as well as unfairness when it comes to hiring practices. And so the idea is that, going to school, going to college is supposed to help build your life, enhance your life, better your life. But oftentimes we are seeing poor college graduates and not seeing the impact that they want to see. And so when we talk about this racial justice lens, we have to recognize that the weight and the burden of student debt is not the same for all people, right? When we talk about Black women, some of the most educated in America today, degrees on degrees on degrees, and recognizing that there is consistently a disproportionate amount of student debt that they face. We have to really think about this as an opportunity to reshift this conversation. And so when we talk about student debt cancellation, and when the NAACP was advocating for $50,000 in student debt to be canceled or more, it was really from this angle of pushing the president to understand that we don't have the same amount of debt, that the cost of education across this country is different, and the cost and value that we see it is very different. And so there has to be a racial justice lens when it comes to any type of cancellation plan. And so we were very pleased to see that there was going to be $20,000 in student debt canceled for those who were recipients of the Pell Grant, right? Recognizing that I believe 74% of HBCU students are Pell Grant recipients, right? We recognize that this is something that is deeply and intimately tied to Black borrowers. I myself am a Pell Grant recipient. And so we have to recognize that, those type of discretions or those type of differentiations when it comes to a plan are helpful to really address it, right? We know that this doesn't hit everything, but this is definitely a start and something that we want to make sure that we continue to push forward, because really at the end of this is about reducing the racial wealth gap. Canceling student debt gives us so many opportunities to really level the playing field and to right the wrongs of the past, right? It's really convenient that, folks had to start paying for tuition the moment that Black folks started to integrate into predominantly white institutions. And so we have to really understand that things aren't by accident, things are on purpose, things happen to deter people from being in places and spaces that allow us to have economic mobility in this country.
Thank you. Thank you for that. So Jeff, in August of last year, the Biden administration announced a plan to cancel some student debt. Can you tell us about that plan and how it would start to address the problem of student debt?
Certainly, and thanks, Katie, and thank you, Demand Justice, was such a valuable and important ally to NEA in many spheres, and to Mike and Wisdom. I'm just honored to be talking with you today, or talking along with you today. I also like to say real quick, at the rally, I was so impressed by all of the transparency and all of the, the messages that were coming through, and we'll probably talk about the rally in a few minutes. One of the things that came through that was really just rang true for me is people telling their own story. And this isn't a time for me to offer testimony, but I want to say that I was a borrower. I went to law school. I had a fair amount of merit-based and need-based help. I went through my undergraduate education, thanks in part to a Pell Grant, Pell Grants I received and my sisters received. And I carried debt until I was 47. I feel very lucky to say it was only through 47 that I was able to pay off my student debt. But I was out of law school for 20 years, working as a legal aid lawyer, a labor lawyer, and I understand some of the struggle about how it can hold us back. So we're pretty well. I think many people are well familiar with the terms of the debt cancellation plan. After years of advocacy by NEA, by SBPC, by the NAACP, and other partners, finally, the Biden administration made good on a promise to address the student debt crisis, kind of, right? Kind of. The administration announced in August that for individuals with federal loans, that the administration would cancel up to $10,000 of those loans. I say 10 up to because there was no credit that would be given if you had less than 10,000, but up to 10,000 per borrower. And then an additional 10,000 for individuals like myself and like Wisdom, who financed our education with the help of Pell Grants because we were in a lower income bracket when we were in school. So it was up to 20,000 per borrower, which was great. It wasn't enough, but it was great. Unfortunately, the administration also saw fit to means test the program and impose income thresholds of $125,000 for individuals and $250,000 for couples. So you had to be under these income thresholds in order to qualify. It was an all or nothing proposition. If you were under, you got it. If you were over, you're not going to get it. We know that this left many people out in the cold who are just as deserving, even if they are somewhat over these income thresholds. We also knew that this would further complicate the application process. I will say that the Department of Education put together a very, especially relative to other programs, very streamlined application program, and we should applaud them for that. However, it is not an automatic program, and even, I will say when, but maybe if, the Supreme Court allows the plan to move forward, people will be left out because they won't navigate even the somewhat streamlined application process. And we know that to be true. So it is disappointing that it was means tested rather than just taking these amounts off the balance sheets with the stroke of a pen. So those are the two, those are the basic provisions. We know that because of the streamlined application process before the program was put on hold, thanks to the pending litigation, 26 million people had submitted applications, which is just a remarkable number in about 4 weeks during which the application was open. 16 million were already approved for relief. They had that in their hand, just so close to having that happen. And then we know that, the states, the 6 states and then the 2 borrowers and several others in other areas raced into court, lobbying all sorts of challenges at the plan that we'll certainly discuss today, and put that on hold and took that away from them temporarily and possibly permanently. Now, just a little bit more on who this impacts. This would wipe out the student loan debt of 20 million borrowers. 20 million people will have their balance reduced to 0, and more than 20 million more will be that much closer to the promise of, student debt relief, and of maybe finally one day seeing a light at the end of the tunnel to pay off their debt. Wisdom gave just such a lovely summation of how this is a racial equity issue. I'd also note that this is an issue of age, right? We have many younger borrowers. I think it's 21% of borrowers under the age of 25 who may be looking to get out into the workforce and kind of start their post-education life. We have 5% of people who hold student debts are senior citizens, and we have everyone in the middle, people looking to buy homes, people looking to further their careers, or maybe have the freedom to take a career in the public service. All right, I started out as a legal aid attorney for years, earning a comically low amount of money. Right out of law school, out of a pretty good law school that cost a pretty good penny, I was earning $26,000 a year. I did it as long as I could, but I can only keep it up for so long before I was approaching financial ruin and made a decision for a career change. But would I consider going back to a legal aid office? I might. It just wasn't in the works for 20 years as I was paying down my student debt. So between that, retirement, home ownership, maybe starting a family, these are all things that people have had to delay. We know that women are 2/3 of all borrowers, which is not without great irony, given that when they achieve their education and enter the workforce, they make 26% less than their male counterparts. We know that, and I saw this statistic the other day, these are like water drops. They just keep drip, drip, drip. You find more facts and more facts that 51% of trans people in this country have student loans. Again, the numbers just don't stop about how this is crushing people in a variety of different ways. And so the debt cancellation plan will go a long way towards addressing that. It won't solve it, but it'll address it.
Yeah. So as Jeff mentioned, 6 states led by Nebraska are challenging the student debt cancellation plan. Separately, 2 people who themselves have student debt have sued over the plan. We'll get to the merits in a minute, but a threshold issue with both of these challenges is whether the challengers have what's called standing. Essentially, that means in order to sue in federal court, you have to show that you've suffered an injury and that a court would be able to address that injury. So Mike, can you talk a little bit about how the states and individuals are claiming that they have standing and why that has left a lot of people, me included, pretty unconvinced?
Absolutely. And I am going to be a little more lawyerly about this than I normally would in a webinar, because this is a demand justice webinar and it's why we're all here. But I think it's important to note that the courts over the past couple of years have slowly started to dispense with centuries of norms around who is able to bring cases and get remedies from a judge. We see that here on steroids. The individual case, the Brown case, where 2 borrowers have alleged that they are harmed by an abusive process that doesn't really exist. Fundamentally, what you have are borrowers. One is left out of a program. So this is somebody that is just aggrieved that the government is spending money in a way that they don't like. It's effectively a dressed up taxpayer standing suit, something that courts have never entertained, but in this case, they seem to. And the other borrower is one who got $10,000 worth of debt relief, thinks that it's unjust that he didn't get $20,000 worth of debt relief because he wasn't a Pell Grant recipient. And so as a result, again, to Katie's point about remedies, nobody should get anything. This flips the norms around who's able to bring a case in front of a federal judge on its head. The courts have been extremely dismissive of a broader theory of standing when state governments start to challenge emergency actions by the Trump administration, when individuals try to seek justice from big corporations for ripping them off. The movement conservative legal project has narrowed the way people can get into court and how they can stay into court over the course of decades and made it nearly impossible for working people to get justice for violations of their rights. But when you have a dark money-backed ideological crusade by opponents of progressive policy, apparently the courthouse doors are wide open. On the state's case, this is maybe even worse. You have 6 Republican state AGs, 5 of whom have basically no claim to standing because their states are not harmed by this, but have dressed up some procedural arguments that even the Republican judges that paused the student loan program in the 8th Circuit didn't find compelling. And then you have this one state, the state of Missouri, that has a questionable relationship with a student loan company that I imagine many of the folks on this call are working in public service and are pursuing public service loan forgiveness and have had to deal with MOHELA before. But MOHELA is a private sector firm that the state of Missouri created to do some stuff in the student loan system that they don't even do anymore. They have existed since the early 80s. They are also going out to Wall Street and Silicon Valley and cutting deals with banks. They're the loan company that SoFi uses to service its student loans. They're basically just a big financial services firm that happens to have been chartered by the state of Missouri. They don't give any money back to the state of Missouri. In fact, they have some obligations to give Missouri money and they don't do it. But because they exist and because the state of Missouri created them, the right-wing attorney general in Missouri says that Missouri is harmed by this program because it will mean less business for their favored student loan company. And again, this is just layers of rhetoric on top of a set of facts that don't really exist. And a critical court that cared about facts and cared about the law would have dispensed with both of these cases outright. And in the state's case, we actually had a Republican-appointed federal judge, he was a George W. Bush nominee, in the Eastern District of Missouri, that looked at this case and said, this is wacky. You do not get to stay in my court, and kicked the case out. But unfortunately, because the Trump administration has just pushed the judiciary so far to the right, the states were able to appeal to the Eighth Circuit, and a panel of Republican-appointed judges put the case back on the docket and paused debt cancellation for everybody. And that's how this got in front of the court. It was the administration trying to reverse a pause in this program that was done after a trial court judge said that this was not a valid case, that these states did not have standing. So sorry, that was kind of a long-winded explanation, but the thrust of it really is that neither of these cases would have made it anywhere near the Supreme Court if they were filed a decade ago or even 4 or 5 years ago. This is just a function of the right-wing drift of the courts and dispensing with centuries of norms around who actually gets to bring challenges in court.
Yeah, thank you for that. As anybody who's been on a demand justice webinar before knows, we are also baffled by, the dispensation of rules and procedures and how that's being used to sort of further a right-wing agenda, as it appears to be being used here too. All right, so that's the first hurdle, standing, and the Supreme Court could still decide that the plaintiffs here don't have standing. But should the court find that either or both sets of challengers have standing, then Jeff, what are their arguments for why this cancellation plan is illegal? And what is the Biden administration's response to those arguments?
Sure. Thank you. I think that the statement you just made in response to Mike's answer, you'll probably just want to repeat as soon as I get done talking about what we think the court is doing here, or some of these arguments here. I also want to say that, really getting into the meat of the argument, Mike, Wisdom, please flag me down, come off mute, interrupt me, and jump in on this, because there's a lot going on at the court, and I will try to boil it down, but please jump in, certainly if I get anything wrong, and if you want to add more nuance to the answers. So there's a few arguments that are at play here, and they all revolve around this. Did Secretary Cardona have the authority conferred by or granted by Congress in the HEROES Act of 2003 to cancel student debt? And how should the court review what the secretary did? So kind of a narrow and then broader question here. So the HEROES Act, first we have to start with that and what it does. And so briefly, in 2001, in the weeks and months after September 11th, Congress granted authority on a number of executive agencies to take action to help respond to this national tragedy. In doing so, I think it was in December of that year that Congress enacted the HEROES Act. And this said that in response to September 11th, the Secretary of Education could waive or modify any, I stress this so much, any statutory or regulatory provision applicable to student aid that the Secretary deemed necessary to protect borrowers, right? We had all sorts of things. We had the Patriot Act. We had all sorts of weird grants of authority that we could get into that are well beyond this. But here, for the Secretary of Education, it was go forth and take action necessary to protect borrowers in the wake of this tragedy. And the statute says that he or they could modify any statutory or regulatory provision in times of a national emergency, which was a provision where and I'll talk about this, where the act was expanded a few years later, to ensure that affected individuals are not put in a worse position financially. So these are kind of the provisions that we've all been analyzing deeply over the last few months. We have a time of national emergency. It's the pandemic. Some may like to deny that, but we are in a time of national emergency. The act itself defines affected individuals of people who are living within a disaster area. We are living within a disaster area in those terms. So most of us believe that it is just beyond any type of non-frivolous argument that we have satisfied those conditions, or the Secretary has satisfied those conditions. Any statutory or regulatory provision. So let's get into that for a moment. the plaintiffs argue that what the secretary is doing in the debt relief plan by canceling debt does not amount to a waiver or modification of any statutory or regulatory provision. Justice Thomas was buying into this, other justices at oral argument were buying into this idea that, well, that's waiver, that's modification, that's something less than outright cancellation. However, when you talk about what waiver means in modification, then let's also look about any statutory provision. Well, it's because of the statute or statutory provisions that govern financial aid that we have obligations to repay that loan, just to put it, terribly simply. So if the secretary has the authority to waive or modify those provisions, they can waive or modify effectively what we have to repay, whether that's by reducing someone's balance by $10,000 or $20,000, or doing so which completely wipes out someone's debt. It is in no uncertain terms, as Justice Kagan forcefully declared, could not be more clear that this is a waiver or modification of the statutory provisions that govern financial aid. So we feel like we are on extraordinarily good footing if we are going to take a textual analysis of this, that the secretary did what Congress, said that the secretary could do. But of course, textualism only gets you so far until it's inconvenient. And we are seeing that from the court now. We saw this from the lower courts, that we can look closely at every comma and every period and every or and every modifier. But if that doesn't give us the result we want, or a road to that, and by us, I mean, that's what they would be arguing, then let's look beyond textualism to some fairness arguments that I think we'll probably get into a little bit later. So we have the waiver, the modification, then we say, are the borrowers that are covered by this plan really going to be left in a worse position financially because of the pandemic? Now here, it's not that simple, because Congress said that the secretary had to ensure that people are not left in a worse position financially. So it may be overbroad. There may be people who are not at risk of being left worse off financially, but we are not looking at those people. We are looking at the people who will be. And the secretary and the Department of Education engaged in a lengthy study that was published in August that sets forth the data for why they were able to conclude that forgiveness in the amounts of $10,000 up to $20,000 for individuals with incomes of $125,000 up to $250,000 in income is essential, right? And ordinarily, that's the end of the story, right? That's what the court would be looking at. Did the secretary do what the secretary is supposed to do without the court delving in and second guessing what was done? Did they do what Congress said they could do? And in this case, the answer is yes, but not content with that. And going back to Mike's point about kind of these broader right-wing efforts, here we have a broader right-wing effort to essentially dismantle the administrative state, right? Because what does the administrative state do? They protect our air and our water and our workers' rights. They protect the rights of borrowers, and in a host of areas across the board. They take the action that Congress allows them to take, and that our constitutional system requires them to take to run a functioning, very extraordinarily complex government. And ordinarily, the court will give great deference to those type of actions taken by the executive branch, unless it's inconvenient to do so, unless doing so results in a policy that they don't like. So what can they do other than take away that level of deference? They can, well, here's what they've done in this case, right? They have said, if we have what has come to be called as a major question, then the court should be skeptical. A major question that the executive branch attempts to answer, the court should be particularly skeptical of that action in sitting in review of that action. So while ordinarily they may say the EPA or the National Labor Relations Board or other bodies, we might not like exactly what they did, but they did it the right way, and so we're not going to second guess the result. Not so fast, not if there's a major question. Now, what is a major question? God only knows at this point, right? This is a doctrine that, to be fair, has been developing over decades, although it's only recently been cemented in the law firmly in June of last year, when the court said, what's a major question? Can the Environmental Protection Agency, in administering the Clean Air Act, can they take extensive measures to provide and ensure we have clean air? Right? I mean, I don't know, Mike, wisdom, if you think that I'm overstating that, maybe, but that's a major question. So suddenly the EPA doesn't have the right to do that unless the Supreme Court can sit with a very skeptical eye and say, can you really do that without Congress doing more? They're saying when the major question exists, Congress needs to say, thou shalt cancel debt through legislative action, or the Secretary of Education shall cancel student debt or has the authority to cancel student debt without limitation, right? Like using explicit language that is unheralded. But that's where we are. We can talk, I could rant more about the major question doctrine, but unfortunately for now, at least, it's here to stay. And it came, on all squares here when the plaintiffs came in and said, this is a major question. Certainly back in 2001, Congress did not mean for the Secretary of Education to broad scale cancel student debt at such a high price tag. And what this really boils down to is the price tag, right? Chief Justice Roberts made that abundantly clear minutes into the argument when he, for the first of several times, mentioned the projections that this could cost in excess of $400 billion. So it's really expensive, except that argument ignores many of the facts, some of which we tried to set forth in our amicus brief, that even at the time when Congress enacted the HEROES Act and then made it permanent in 2007, the federal government had a student debt portfolio of like $560 billion, 28 million borrowers. It should be evident to all that if you're going to modify a provision or waive a provision, it's going to be expensive, right? They had the data in front of them at that time. It was undeniable that it was only continuing to increase. So the idea that it's expensive is not, and it's not an extraordinary one. It is not, it should have come as no surprise to Congress back in 2007. And yet here we are in 2023 and 2022, and Congress is, the court is suggesting that it needs to sit in super review of what Congress was doing back in time to call into question what the executive branch was doing, thereby inserting it directly into, as you pointed out earlier, a political controversy that frankly the court should have very little say, other than blessing it to say, Congress said the secretary can do this, the secretary did that. That's the end of the story as far as judicial review should be concerned. But of course, it wasn't. I think I've talked long enough. I may not have covered your entire question, but I'll pause for just a second.
I do have one follow-up question for you, Jeff. In the NEA's brief, you said that the major questions doctrine could, quote, harm not only the administration of important administrative schemes validly enacted by Congress, but also this court's standing and legitimacy as a neutral, non-political arbiter of the law, end quote. I feel like you touched on that a little bit, but I wonder if you have anything else to say to that statement specifically.
I do, and I want to say that lovely sentence in our brief was, I wish I could take credit for it, but it was my fantastic colleague Jason Walta who put that in there. Credit goes to where it's due. Simply put, it just puts far too much discretion into the judicial branch to influence federal policy. Deference exists for a reason. It's because we should allow Congress to decide what laws should be passed. We should allow the executive branch to act within the sphere of its expertise to carry out those policies in our extraordinarily complex federal system. And the court's role in this, in reviewing the actions of the executive branch in this instance, should be kept at a minimum. But instead, what they're doing is they are reaching out. Let's talk judicial activism for a minute, but I'll set that aside. They are reaching out to say, we want to have more of a voice in the political process of what the government is doing, in this case, canceling student debt. We want to be able to just characterize something through a nebulous test that is just ill-defined. We want to be able to say we have the right to step into this beyond which our administrative law has ever provided in decades of development, including the Chevron deference that's typically afforded to executive agencies. We want to set that aside for the moment. And if we say it's major based on our own characterization, then we have a greater role to play and greater skepticism of what the executive branch is doing. So I think that does illegitimize the court because it is just, giving more, just heaping evidence on existing evidence that the Supreme Court wants to be a political player, despite the fact that that's not what it's designed to do in our constitutional structure.
And I hate to jump on this and drag it out even more because I do feel like we're going way down the rabbit hole here. But
drag the Supreme Court. It's our favorite thing. I
am here to drag Sam Alito in particular. When you listen to Justice Alito, who is, I think Alito and Gorsuch both have really tried to bring this major questions doctrine some legitimacy by articulating a framework for what isn't a major question. Again, that only works until you get to a place where your prior commitment to some legal rigor runs square into your policy preferences. And we've watched Justice Alito in oral arguments here bring up this idea of fairness that seems to cut against the entire movement conservative judicial project. And introduces from way outside of the statute and way outside of the government's rationale and way outside of Congress's intent, this idea that there is another constituency the government needs to consider, which are people who don't benefit from a public policy. And the way the government is supposed to work, they're supposed to make trade-offs, they're supposed to make decisions, they're supposed to run programs. And here the court, because it doesn't like the outcome, is introducing some other test that I kind of jokingly, on Twitter when we were watching this hearing, called vibes. But I think that that's right. Like, Justice Alito doesn't like the vibes, and he can't get the law to give him a way out here. So he's just going to call it on the vibes. And it's a major question because the vibes are off. And we're in this place now where this is going to justify the court shutting down every progressive project that comes out of the executive branch if the Supreme Court's conservative majority doesn't like the vibes. That's not justice. That's not the law. That's not even really norms. That is just vibes.
Yeah, so you brought up the fairness argument that we heard a lot of justices question about, and so I wanted to throw this to wisdom. That was an interesting argument that was being made basically by the justices. I'm wondering if there's any legal basis for this line of questioning about the fairness of the plan, and sort of what your response is more generally to that argument that there's something unfair about this plan.
Yeah, just as a disclaimer, I'm not a lawyer, but the way that this conversation is going, if we see this debt canceled and get free college, I might need to go to law school because I really appreciate the insight that I'm getting here on this call. When I think about this argument of fairness and this question of fairness, I think one, this is not even really the issue that's being examined in this case, right? I think that oftentimes distractions are being put into place, right? I appreciate the idea of thinking about fairness, but the idea of fairness is we have to think about it from a broader perspective when we think about education, when we think about college, when we think about student debt, right? Recognizing that there are so many young people of color who are in these institutions of higher education who are struggling just to make it day by day, right? I can even go back to my own experience. There's moments and times where I was houseless, where I didn't have food, where I had to make decisions to say, hey, am I going to stay in school or I'm going to make sure that I have a meal? And so there are so many sacrifices that people go through because of what is told to us, right? The belief is that you go to college, you get a good degree, and you get a good job, and you're able to provide for your family and do those things, right? And I think there's this idea that's been floating around that, folks have to pay their student debt because you made the choice to do that, right? There have been so many opportunities where people have been bailed out and our banks that have been bailed out. And so that if we are going to bail these banks out, then we got to bail our people out, right? We have to keep that same energy. And so there are so many things that are happening within our government, within our system when it comes to our economy that are unfair, right? If you're going to bring up fairness when it comes to student debt, you need to get in line, right? There's a long list of things that are unfair. Right. This is a public good. This is a social support. This is an opportunity to allow us to reduce the racial wealth gap and to be fair. Right. We really want to make sure we can set this up along this fighting, as I kind of hinted at earlier. Right. Really thinking about the value and cost of higher education, right? This idea that the fight for student debt cancellation is intimately tied to the fight for free college, the idea and the opportunity for folks to access these places and spaces of higher education and to better their lives and to get those opportunities, to get those good paying jobs, to help and support their families, to start businesses, to become homeowners, and to build generational wealth, right? That's really what it's about. And so when I think about this question of fairness, I see it as a distraction. I see it as, again, as we've been talking about in this conversation, ways to stomp out the vibes. And I know, as the director of the Youth and College Division, working with Gen Z, and we operate in vibes. Our Gen Zers know that canceling student debt is a vibe. It is the way to go. It is the way that's necessary. And we saw people show up and show out to ensure that their voices were heard, right? Because at the end of the day, this is about people, right? Folks keep talking. I know it's a policy, but this is about changing people and supporting people in our future.
Thanks. So Mike, I wanted to ask you, regardless of what happens in this case, we still obviously have a lot of work to do to ease the burden of student debt. What other ideas should Congress and the Biden administration be considering?
So I think there's a big answer here and a small answer here, and I'll start with the small one, but then I want to end with the big one. The small one is there's lots that the administration can do to fix the broken safety net that's supposed to prevent student debt from being a lifelong burden and from driving people into financial distress. That includes making income-driven repayment the principal safety net program for lower-income folks, protect more income, stop the debt trap, stop charging interest when people are making monthly payments. They're kind of technical things that you can do to make the student loan system work a little bit better. That includes driving mass debt relief, but maybe not at the level we're talking about at the Supreme Court, through income-driven repayment and through public service loan forgiveness and through discharge programs for people that have been defrauded by for-profit schools or have had a school close or have become disabled. The administration is doing this work right now. Millions of people are already debt-free because of reforms to these more targeted debt relief programs. The one silver lining to this big fight to cancel debt for everybody is that it's actually opened up this policy space to cancel debt for masses of people by the hundreds of thousands, not by the tens of millions. And for those people that are debt-free, this stuff is life-changing, and it is making a difference, and it is building a better student loan system. The debt itself is a problem. Like, people shouldn't be driving themselves into punishing debt to go to college. And as Wisdom said before, like, we need free college yesterday to actually be able to address the root causes here. And we need much more debt relief to right the scales. But there are good things happening in the student loan system because the president is listening to people and doing the things that they are asking. And this is the first time, I've been doing this for a long time, and this is the first time that I have ever seen an administration actually take seriously their mission to deliver debt relief to people. Part of what got lost in the Supreme Court case is that the student loan system cancels debt every single day. It always has. It didn't do it well. It didn't do it equitably. It didn't do it in a way that was expansive enough to actually address the problem. But canceling debt is normal. And all we're talking about here is scale. We're debating scale in front of the Supreme Court, not whether or not the law allows the Secretary of Education to cancel student debt, because he does it every single day. So the big answer here is that the Higher Education Act lets the Secretary of Education cancel student debt. And he gets to decide the program he puts in place to cancel student debt, whether that's based on income or based on where you work or based on whether you're disabled or based on whether the debt itself is never going to be repaid and it shouldn't be on the books in the first place. The secretary has this broad power to define how and when and under what circumstances he cancels student debt. And so we're watching. We'll be watching the day this court case gets handed down to see what the administration does next. And if the past is any indication, we have an administration that listens to people, cares about their needs, and wants to deliver. And so we have high hopes, even if this court strikes this down, that we're not done yet.
So I wanted to sort of give you all a chance to weigh in on what you think the potential outcomes of this case are and what you think the most likely outcome is based on what we heard in the oral arguments.
I mean, I'll jump unless someone else would rather go first, unvarnished. I just could not agree with Mike more that these standing arguments are nonsensical, and they really do risk opening the door to litigation that just doesn't belong in court. NEA has been recently involved in a few taxpayer standing cases, for instance, that should go nowhere. But how will this impact that? We don't know. How will it impact other cases in which just general grievance want to come into court and challenge things despite the fact that there's no real connection, no real injury that they're suffering, which is kind of the hallmark of constitutional standing. That said, I don't think that they're going to have any problem finding standing in the case with the states. I shouldn't say no problem. They may be grappling with how to minimize it, but I think that they will find a way to write around this. I was kind of thinking about a clever way to say this and didn't come up with one, but they always say that prosecutor can, get a grand jury to indict a ham sandwich or whatever. But I think something is equally true about the standing doctrine. That if a court wants to write around it in order to further to reach the merits and further their position, they're going to do it. The only justice from the right that showed any real skepticism in oral argument was Amy Coney Barrett. She was really engaged on this to an extent that I think many people found surprising. Unfortunately, I just didn't see any tea leaves to read that Roberts or others were concerned about this. Roberts, we always like to give him credit for protecting the institutional standing of the court, but he didn't seem to have any problem here, and he really just wanted to get into the merits and delve deep on the merits itself. And then I'll hand it over. On the merits itself, I think that it's even less likely that we will prevail. I think that they're going to go by hook, line, and sinker into the major question doctrine and use this as an opportunity to strike down the program. And it is an all or nothing proposition. They can't whittle it down and say, well, 125,000 is too much, but for borrowers with less than 75,000, they should get it. They don't have the authority to do that. So it's either a yes or no. And unfortunately, I think it's going to be a 6-3 against to strike down the plan. I hope Mike and Wisdom can convince me I'm wrong.
I would just say I'm a little more hopeful than that. I think that you can infer something from the silence on the standing questions by Kavanaugh and even Thomas a little bit, and also Justice Roberts, who really didn't push one way or the other, that maybe there is a coalition to be built that gets you to 5 to kick these cases out. And I don't know that that's the likely outcome. Like if you made me bet, I'm probably not going to bet on this surviving with this court in this moment. But if you're starting with 4, if you're starting with Barrett and the 3 democratically appointed justices, you could see some kind of escape hatch. And I think the Solicitor General did a very good job of leaving the conservative justices a way out of this case without having to ratify a policy they obviously very viscerally oppose. And you could imagine success here looking like kicking this case out on standing. And I think the Solicitor General was very smart to say, if the student loan company Mohila brought this case, it would have standing. This isn't a policy that no one could review. The government didn't build something that's not subject to judicial review. It's just that these parties aren't the right parties to bring this case to the court. And you could see a path out for a majority if they wanted to I think Jeff put it right, do something to shore up the court's legitimacy on the heels of a series of extremely anti-democratic and extremely unpopular rulings. There is a way out here. So yeah, go ahead.
Can I just jump in before Wisdom? I just want to say one thing. I wanted to say it earlier, and that is that, yes, we're saying that the administration has taken this life-altering, never before even done action. But I just want to also say that in defending this action, at least at the Supreme Court, the Solicitor General was brilliant, right? She was there. It was a 3 hour and 5 minutes worth of arguments. She was up for about half that time. And I think she really knocked it out of the park and just so buried her competitors. That doesn't necessarily buy you anything when it comes to the outcome, but they really couldn't have gone harder. And I was just so impressed that I think that's worth saying early and often. Sorry, Wisdom.
All good. I think, I agree with both of you. I think that our faith in the Supreme Court isn't high, right? We saw what happened with Roe. We're seeing what's happening in the discussion happening around affirmative action. And I really believe that, if the Supreme Court wants the people to put their faith back into the system, into this government, that they do make the right decision. But regardless, right, as Mike said earlier, it's not done until it's done. Right. So regardless of the decision that the Supreme Court makes, there is still opportunity. There's still power to make this happen. And that's what I'm focused on. That's what we're focused on. That's what we are essentially continuing to push forward, because there is a path forward. Right there. This is not a checkmate. This, it's an Uno reverse, as some of my young people like to say, that we are still going to keep fighting for this. We're still going to keep putting forth our messaging, because we recognize that student debt cancellation is legal and is possible and will change the lives of millions of Americans. And so I think it's really important for us to continue to push people to dream. We recognize that, there are people in place who are organizing against us, right? Who are sending out people to ensure that this doesn't happen, right? Because they believe it's not fair, or because they, don't see this as an opportunity to really move their agenda forward. And there are bigger plays happening at force as we attend upon the 2024 presidential election, right? There are all these attacks that are happening all across when it comes to education, when it comes to higher education. And so we really have to be adept to what's happening at this moment in time. I do think that we can continue to do our part and continue to ensure that we're telling those stories that are absolutely necessary to showcase how this is a key issue, right? Over the last decade, student debt has grown and become a cultural phenomenon that it is bigger than the Supreme Court. And so regardless of what the Supreme Court says, we're still going to fight, we're still going to organize, and we're still going to win.
Thanks, Wisdom. I wanted to ask you, so there have also been a couple of mentions of the rally that was in front of the Supreme Court on the day of the oral arguments, which had a really great turnout. And I wonder if you could just talk a little bit about who organized that action and what the message was intended for it to send.
Yeah. So that phenomenal, mobilization and action at the Supreme Court was what I like to call a labor of love by the Student Debt Avengers, right? This group and this coalition that has kind of formed really over the last 2-3 years in the wake of the pandemic, doing different actions, doing different ways in which folks can come together, to really address this student debt crisis that is happening. And so this coalition of folks, Student Debt Crisis Center, NAACP, Center for Responsible Lending, We the 45 Million, many more organizations in the civil rights spaces, really kind of coming together to really ensure that this happens in this moment in time, was really to kind of say that this is about the people, right? That we recognize that student debt cancellation is legal and that we want to uplift the stories of borrowers. It was phenomenal to see so many of our elected leaders come out, right? Bernie, who has always been a champion for student debt cancellation, Senator Elizabeth Warren, who's always been a champion and an ally in this place and space, has been a phenomenal ally. Becky Pringle with NEA, coming out and speaking to our young people, speaking to the intergenerational group that was there, because we recognize that student debt is an intergenerational conversation that impacts all of us. The NAACP, we just turned 114 years old, and we have members who are part of our older generations who still continue to have to pay down their student debt. And so I think this was really a stand. This was our opportunity to fight back all of our efforts that we have been putting together for years and years and years, to really make sure that folks understand that we're going to see this all the way through, right? And that recognizing that regardless if the Supreme Court is hearing us or not, that we're here and that we're going to keep fighting.
And if I could just add, it was fantastically successul at framing the stakes of the fight here. The headlines were grim the next day. Every paper led with a story about the conservative majority skepticism for student debt relief. And right next to that bad headline was a picture of the people who were going to lose out. And that's because people turned out. And we saw that on the front page of the New York Times and the LA Times and the Boston Globe. And these were pre-written stories. The reporters wanted to tell a story about how a conservative majority was going to snatch debt relief away. And they wouldn't have centered the experiences of the people that are going to suffer from this miscarriage of justice if it wasn't for the fact that people showed up in front of the court and made reporters look them in the eye and tell their story too. And that's a reason that activism works. It was a huge credit to NAACP and NEA and the unions and civil rights groups for turning out their members. It worked. It did the job.
So we do have a couple of questions, and if we don't, time is running out, but if you have another question, please feel free to put in the Q&A. But I was going to take moderator's privilege and address one of them from Dolores, who asked about whether we should be looking at restricting the Supreme Court's power to review anything and everything. And I will just say that we at Demand Justice spend a lot of time thinking about and talking about various types of reforms to the Supreme Court. So our sort of signature issue is the need to add seats in order to bring balance back to a court that's been like intentionally manipulated by political actors into being sort of a rubber stamp for the conservative agenda. So we fully support adding seats, but yes, we also are supportive of the idea of jurisdiction stripping, changing the ways that the Supreme Court can accept cases and can strike down congressional actions. So all of those sort of reforms are on the table, and there are a lot of people looking at them. And I think with every bad decision that we see, obviously last year was pretty devastating with the Dobbs decision overturning Roe versus Wade, and with the Bruin decision really, really narrowing how we can pass gun violence prevention measures. Every one of those decisions is a wake-up call that something needs to be done to sort of rein in a Supreme Court that's gotten out of control. So those conversations are taking place. I don't know if anybody else wants to weigh in on that question.
Katie, if someone asked me that question, I would refer them to demand justice. I certainly have feelings on it, but let's defer to I will choose to defer to the expert in the room. And I have to say, I completely agree. And obviously, NEA supports demand justice's efforts in these areas.
So another question is, if the Supreme Court does kick this case out on standing, would you expect another case down the road with a different person or entity bringing the case?
Maybe I'll go first here. I would say those cases are already on file. There are cases in courthouses across the country, including one in Kansas that the Cato Institute backed with a very conservative judge that is just a ticking time bomb here. And it's incumbent on the administration to not waste the opportunity. I think there's again, it's a norm, not necessarily an ironclad rule of law, that it's harder to take something away from people than it is to stop something happening for people. And if the administration moves fast and cancels these debts, at least there's a shot that for the 16 million people who have approved applications on file, the next challenge won't have as broad of an impact as this one would, should it get all the way up to the court. But there's also something to be said for the court not wanting to deal with this twice. Like they're if they give themselves a way out here, I would imagine they would do it in a way that walls off having to hear this thing again, because they are still political actors. They're aware of how widely popular across demographics and ages and race and geography this program is, and they're not going to want to keep making themselves the face of the fight to take something away from working families. But yeah, there are cases on file ready to go. Sorry, that's a long way of answering your question.
Thank you. And so we have about a minute left. I want to give you each an opportunity to weigh in on my last question, which is just what advice do you have for those in our audience who have student loans right now? And what advice do you have for people who want to become activists on this issue, regardless of what happens with this case?
Yeah, I can start off with this one. Again, it's about our stories, right? We have the data, we have the research, we have the legal experts on deck, making sure that we are fighting back at every single level. But we have to continue to tell those stories. I think, the stories that were amplified, particularly about Black borrowers, have really allowed us to make a difference and to show the impact that student debt has on many of our lives. And so if you have not already, I definitely would urge you to go to naacp.org, become a member if you're not. But also there is an opportunity there for you to share your stories, for you to record stories, for you to write your stories out. We are going to be publishing those, making sure that we're consistently having those narratives in the media, and combating anything that is saying that this is not going to be supportive or otherwise. And so we want to make sure we continue doing that, but also continuing to make sure that we are building activists and organizers who can address this, right? I think there's definitely a need for state level education and people to really make sure they can understand what's happening on the local level, right? What's more impactful than all of us here talking about this is the micro influencers and people who in your community who can speak towards student debt cancellation and why this is needed in this moment in time.
And I'll just take a quick stab at the separate question, Katie, of what borrowers can do. In addition to becoming activists, there are other programs. None of them are in any way as helpful or as impactful as outright debt cancellation, which is what we need and what people deserve, right? There are programs, and I guess the only thing I can add to existing programs is revisit programs if you haven't in a while, because things are improving, right? NEA all of us have done just a lot of work around the public service loan forgiveness program. So if you're in public service or looking to be in public service, recognize that the program has improved, whereas only 16,000 borrowers had ever received full forgiveness under the public service loan forgiveness program as of, I think, 2021. The Biden administration implemented a limited waiver that helped push a lot of people forward and is now continuing to make improvements to that program. So that promise may be far off in the horizon for some, but it does exist. It is improved over the last few years, and hopefully it will continue to improve. And then second, there's a new income-driven repayment program. So if you're feeling overwhelmed with your monthly payment, things may very well improve for you if you qualify for this new income-driven repayment program that is coming out in a few months. It's not just another, I don't believe it will be another kind of false promise. I think it will make a true and impactful change in at least lowering people's monthly payments and bringing them closer to forgiveness under that separate program. So there is some hope out there, but again, I recognize that it is only of limited value, especially if folks have just overwhelming amounts of debt and feel lost and trapped, which is many.
And I'll just make a plug for cancelmystudentdebt.org, which is a resource that is managed by our organization, but is a coalition effort here, and shows a way out for folks through some of these smaller programs, and also provides up-to-date information about the state of the court case. So cancelmystudentdebt.org has lots of great resources.
Well, we have run out of time. Thank you all so much for joining us for this conversation. Thanks everybody who is in our audience. It was recorded, and we will share a link in case anybody just can't get enough of it. And have a great rest of your week. Bye, everybody.
Thanks, Katie. Thanks, everybody.